This is Courtroom Chronicles, a platform dedicated to bringing you real courtroom cases and unfolding legal stories with precision and depth. We provide detailed accounts of trials, hearings, and sentencing proceedings, ensuring that you stay informed about the justice system in action. Let the record show that the state's representatives, the defense counsel, and the defendant are all present. We are gathered here for sentencing. Before proceeding, is there anything else the court needs to address? No? All right. I have carefully reviewed all testimony, evidence, legal arguments, applicable case law, and relevant statutes. I have also prepared a written sentencing order which I will officially file at the same time as delivering today's sentencing. Copies will be provided to both the prosecution and defense once I finish. In the case of State of Florida v. Wade, Stephen Wilson, case number 19, CF 568, the court will now read the section of the sentencing order regarding the circumstances and proportionality of the sentence. When assessing aggravating and mitigating factors, the court does not simply count them, but instead makes a reasoned judgment based on the full context of the case. Given that the death penalty is an extreme and irreversible punishment, it is reserved only for cases with the most severe aggravating factors and the least mitigating circumstances.
But instead makes a reasoned judgment based on the totality of the circumstances. In reaching this decision, the court is mindful that because death is a unique punishment in its finality, its application is reserved only for those cases where the most aggravating and least mitigating circumstances exist. The law never requires the imposition of a death sentence.
However, the law does not mandate the death penalty in any case. After considering all the evidence, the court finds that the defendant deliberately beat and strangled Christine Melton in her home before stealing her car and driving to meet his girlfriend, Melissa Mons. When Mons refused to get into the vehicle with him, he physically attacked her in broad daylight. After Mons managed to escape, the defendant fled the scene and returned to Cape Coral, where he decided to kill again. He saw Diane Ruiz walking to work, pulled over, and pretended to ask for directions. When Ruiz got into the car to help, he strangled her as she attempted to escape. He then drove to an empty lot, strangling her into unconsciousness multiple times along the way. When she tried to flee from the car, he ran her over, causing fatal injuries to her spine, ribs, and neck. The evidence establishes that both murders were exceptionally brutal, and the second murder was particularly cold, calculated, and premeditated. The victims endured severe physical and emotional suffering. Furthermore, the defendant committed these murders while on probation for prior felony convictions. Additionally, he carried out 2 first-degree murders alongside charges of grand theft of a motor vehicle, battery, and burglary of a dwelling.
To the advisory verdict of the jury, who recommended that the death penalty be imposed by a vote of 9-3 on count 1 for the murder of Christine Melton and a vote of 10-2 on count 4 for the murder of Diane Ruiz.
No statutory mitigating factors were established in this case. However, the court did consider 13 non-statutory mitigating factors presented by the defense, of which 10 were found to be valid. Among those, 6 were given minimal weight. The mitigating evidence suggests that the defendant had a history of drug use from a young age and suffered from undiagnosed and untreated mental health issues. Although he felt abandoned by his biological parents, he was raised in a loving and supportive adoptive family. The defendant did not resist arrest and fully confessed to both murders. The court has also given significant weight to the jury's recommendation. The jury voted 9-3 in favor of the death penalty for the murder of Christine Melton and 10-2 in favor of the death penalty for the murder of Diane Ruiz. There is no strict mathematical formula for balancing aggravating and mitigating factors. Instead, the court has carefully assessed the severity and nature of each factor. Having reviewed all aggravating factors proven beyond a reasonable doubt and all mitigating circumstances supported by evidence, the court finds that the aggravating factors significantly outweigh the mitigating ones. Given the facts of this case, there is no indication that the defendant's background or mental state makes the death penalty inappropriate. A review of similar capital cases confirms that the death sentence in this case is not disproportionate. Based on the totality of the circumstances, the court finds no reason to override the jury's verdict. Therefore, the court sentences Wade Stephen Wilson to death for each count of first-degree murder. Sentencing details. Count 1, first-degree murder of Christine Melton, sentenced to death. Count 2, grand theft of a motor vehicle, sentenced to 5 years in the Florida Department of Corrections. Count 3, battery, sentenced to 364 days in Lee County Jail. Count 4, first-degree murder of Diane Ruiz, sentenced to death. Count 5, burglary of a dwelling, sentenced to 15 years in the Florida Department of Corrections. Count 6, petty theft, sentenced to sentencing details. Count 1, first-degree murder of Christine Melton, sentenced to death. Count 2, grand theft of a motor vehicle, sentenced to 5 years in the Florida Department of Corrections. Count 3, battery, sentenced to 364 days in Lee County Jail. Count 4, first-degree murder of Diane Ruiz, sentenced to death. Count 5, burglary of a dwelling, sentenced to 15 years in the Florida Department of Corrections. Count 6, petty theft, sentenced to 364 days in Lee County Jail. The defendant will receive credit for time already served. All sentences will run concurrently, meaning they will be served at the same time. All legally required fines, fees, and costs are imposed as recorded. The defendant is hereby remanded to the custody of the Department of Corrections to carry out this sentence as prescribed by law. The defendant is also informed that these convictions and sentences will undergo automatic review by the Florida Supreme Court. If he cannot afford an attorney for the appeal, the court will appoint one for him. Additional court matters. The prosecution is requesting $7,500 in costs for prosecution. Judge: any objections? Defense: no, Your Honor. Judge: the amount will be imposed. Furthermore, it is ordered that the defendant will have no contact with the victims' families. Regarding other pending cases in this circuit, today is not the time to address them. These matters will be scheduled for September 16th at 9 a.m. under case numbers 20C F116591 and 23C F115499. The court confirms that a hearing is scheduled for September 16th. A warrant for violation of probation, VOP, exists in Broward County and Palm Beach County. The authorities there will be contacted, and if necessary, a motion may be filed to release the defendant on his own recognizance, ROR, for transfer. However, that motion is not currently before the court. Final proceedings. Judge: anything else? Prosecution: nothing from the state, Your Honor. Judge: Mr. Wilson, you will now be fingerprinted and transferred to the Sheriff's Department. You will be held without bond and transported to the Department of Corrections when appropriate. The court is now adjourned. Copies of the sentencing order will be distributed to both the prosecution and defense. Defense and prosecution. Thank you, Your Honor. This concludes today's coverage by Courtroom Chronicles, where we bring you real courtroom cases with accuracy and depth. Stay tuned for more legal proceedings and justice system insights.